Elections have consequences, especially 2016. I'm Michael Smerconish in Philadelphia. The Supreme Court, one-third comprised by appointees of former President Donald Trump, just ended a most consequential term. SCOTUS just put its imprimatur on voting rights, affirmative action, student loans, and adoption. This on top of last year's rulings concerning abortion, guns, religion, and climate change. Yesterday, the court released a much-anticipated opinion concerning speech and gay rights. At issue, a Colorado business seeking permission not to work for same-sex wedding couples, only this time it wasn't the baker. That case was decided in 2018 when Jack Phillips refused to bake a wedding cake for a gay couple. Back then, the court narrowly decided for the baker, but didn't determine whether a business owner's speech rights can justify refusing service to gay couples. Well, 5 miles from the Colorado baker is a graphic artist named Lorie Smith, who'll join me momentarily. She said she didn't want to create any same-sex wedding message at odds with her religious beliefs. She brought up pre-enforcement action, meaning she'd never received a request to design a same-sex couple site, nor had she turned anyone down. Smith won. A majority of the court saw Colorado's public accommodation laws an unconstitutional attempt by the state to compel her speech. The minority cast the outcome as the first time the court permitted a commercial business to refuse service to a protected class. Justice Neil Gorsuch wrote the majority opinion in which he stated this: all manner of speech, from pictures, films, paintings, drawings, and engravings to oral utterance and the printed word, qualify for the First Amendment's protections. No less can hold true when it comes to speech like Ms. Smith's conveyed over the internet. Lawyers and law schools, we love hypotheticals, and both sides to this case came well armed. Justice Gorsuch's majority warned that if the state were successful, the government could similarly require an unwilling Muslim movie director to make a film with a Zionist message or an atheist muralist to accept a commission celebrating evangelical zeal, so long as they would make films or murals for other members of the public with different messages. Or that the government could enforce a male website designer married to another man to design websites for an organization that advocates against same-sex marriage. Justice Sotomayor's minority opinion responded in kind. She raised the example of a professional photographer who's generally free to choose her subjects. She can make a living taking photos of flowers or celebrities. The state does not regulate that choice. But she said if the photographer opens a portrait photography business to the public, the business may not then deny to any person because of race, sex, national origin, or other protected characteristic the full and equal enjoyment of whatever services the business chooses to offer. And said Sotomayor, if the business offers corporate headshots, it may not then deny those services to women because the owner believes a woman's place is in the home. Nor, Sotomayor argued, can a website designer refuse to create a wedding website for an interracial couple based on the opinion that the Almighty God did not intend for the races to mix. How about this one? Could a stationer refused to sell a birth announcement for a disabled couple because she opposes their having a child? Sotomayor wondered aloud. And what about a large retail store that wishes to reserve its family portrait services for traditional families? Where would the slippery slope end? Yesterday, President Biden weighed in, calling the decision disappointing, and said that he feared the exclusion of gays and other minorities by businesses. Joining me now are the successful plaintiff in the website ruling, Lorie Smith, and her attorney, Kristen Waggoner. Kristen Waggoner personally has argued 3 cases before the Supreme Court. She's the CEO and president of Alliance Defending Freedom, a faith-based legal organization that has won 15 cases at SCOTUS and assisted in the legal team that overturned Roe v. Wade. Lorie, thank you for being here. Hypothetical for you: if a gay man who's a realtor asked you to design a website for his business, are you taking that job?
Of course, and it's not a hypothetical. I have clients who identify as LGBT. I work with clients from all walks of life. I cannot create every message requested of me.
You do a great job. This is hypothetical number 2, and then I'll get off the hypotheticals at least for now. You do a great job for a man and woman getting married. A same-sex couple see the website you create and they say, we want exactly that. Just change the pictures and change the date. Don't do anything else. Give us what you gave them. How about that?
I don't specialize in that type of speech. Everything I create is unique and one of a kind. Again, I'm always looking at the message that I'm being asked to create. What I think is really important to emphasize here is that for the last 7 years, the state of Colorado has been silencing and coercing my speech and forcing me to create a message I don't wish to create. Nobody should be put in that position, and the court's decision yesterday protects speech, not just for me, for the LGBT website designer and every other artist out there. Nobody should be punished by the government for speaking consistent with their beliefs.
Counselor, I see you shaking your head. Let me ask you a question. I read the opinion last night. By the way, it's great reading, both the majority and the minority view, and I recommend the dissenting view, and I recommend that Americans who are interested in this take the time to do so. It's written mostly in plain speak. I thought before I read it that this was going to be largely predicated on Lori's religious beliefs, and that is not my takeaway. Instead, it's about her speech, but it makes me wonder, okay, what about someone who's just uncomfortable with whatever might be the client in front of them having nothing to do with faith? Doesn't that open the door for animus to be a determinant?
The court's decision does not do that at all. It reaffirmed a time-honored principle found in our Constitution, which is that the First Amendment follows a golden rule. If we want to protect speech for ourselves, then we need to protect it for others, even those we disagree with. Whether someone feels uncomfortable, they certainly can't deny service because they feel uncomfortable. The court's ruling says that non-discrimination laws continue to apply to ensure that people can't be denied services or goods because of a protected characteristic. But it also says that no matter who you are, the government can't force you to say something that you don't believe. And that's a win for everyone.
Right. You make it sound as if these are black and white determinations, though. I think a lot of this is in the gray area. What exactly is speech? I don't know why so much of this litigation is in a wedding context, but okay, I'll roll with it. So I guess the baker is speaking. I guess the website designer, your client, is speaking. Presumably the florist is speaking, the photographer. What about the stagehand? What about the wedding singer? You know, what about all those ancillary businesses that go into it? Are they all offering speech, or aren't they just there doing a job like they would do for any other couple?
If they're doing a job and there's not speech involved, then the non-discrimination principles apply, and the First Amendment does not in the free speech context. And so I think you're overcomplicating it. As you open, the court's decision, the majority decision by Justice Gorsuch is clear. There are clear tests in the law as to when speech is involved. We know when speech is involved. And here we have the written, printed word. So there's no question that speech is involved. In terms of Justice Sotomayor's dissent, as the majority said, she's litigating a case that wasn't even before the court and on entirely different facts. So again, like you said, Americans should read the decision and decide for themselves.
Okay, I'm in my hypothetical, counselor, I'm an atheist, and I'm in one of these ancillary businesses. And when couples get together in a non-religious environment or ceremony, I'm going to provide my services. But wait a minute, this is a religious wedding. I don't want a part of that. Is that okay?
Well, I'm not sure what your atheist is doing, and so what matters is, are they being asked to...
I'm a florist, I'm a photographer, I'm a web designer, or I'm a baker. But I'm an atheist, and I'm only going to provide these services for fellow atheists, even though I hold myself out to the public.
It's about what the speech is that's being requested. Lori has always made distinctions based on what the message is that she's being asked to give voice to, and that's a critical distinction that the court reaffirmed. The test has always been whether the speaker's message is affected by what the government wants them to say. And that's the test that will continue to apply. The court didn't create new law. They just applied it in a cultural moment where some disagree with Lori's message. And it's important that we stick to protecting freedom because political and cultural winds shift. And if the government can compel Lori, it can compel the LGBT website designer as well. We all need to remember that.
This is a law school dream, this case. Lori, a final one for you. Think of the pharmacist called upon to fill a prescription for birth control who has a religious objection to doing so. I would say, hey, you chose to be a pharmacist, and if you have trouble providing this service, maybe this is not a gig for you. What about someone who similarly says, if you want to be a web designer, you got to serve everybody, and your religion can't come into it? You get the final word.
My final word is this. I create speech for a living. When speech is involved, speech should be protected. This protects not just me, the LGBT website designer, the Jewish calligrapher, the Democrat speechwriter, the pro-life photographer. We all benefit from the court's ruling yesterday.